All right, it's 27 minutes now before 11 o'clock. It's time for the show called Legally Yours. John Fuller is the host of this program. He's an attorney here in Ocala. I'm sure you know that already. He is with the law firm of Fuller & Fuller, which is his own law firm. The other Fuller is his wife, Janet, and the two lawyers together represent many of us here in Ocala. John is here right now to answer your questions. If you have some about the law, the phone number here is the WOCA Climate Control Source Hotline, 622-9622. Good morning, John.
Good morning, Larry. It's great to be here with you today, as always, and to all of our listeners who regularly listen, and to the maybe people who are listening for the first time, we want to welcome them. We really enjoy this show and really appreciate the questions that our listeners call in. We have wonderfully intelligent, very timely questions about our legal system, about specific legal issues. We are happy to discuss it in general terms on the program. If it's an area that falls within civil trial practice, business, commercial law, Social Security, disability, complex major family law case, those are the areas that we specialize in our law firm. And we'd be happy if it's a case that you think you would like to consult with us to go into detail about. You could give us a call and we'd be glad to see you. But on this program, we get to talk about a lot of interesting things. As we've said more than once, there is practically, there's almost nothing in our daily lives that isn't touched upon by our legal and judicial system. And when you start dealing with legal issues, it overlaps because the structure of our federal government, separation of individual states and their rights, all of that has been played out over the years in our courts and sometimes on battlefields during the Civil War. And I think our system isn't perfect. But I've worked in it for almost 40 years, and I am always impressed. I have said this to a number of juries that I've addressed in final summation, closing argument, that in all my years of practicing law, I've never stood before a jury in a court of law arguing a case on behalf of my client that I didn't feel a certain awe and majesty in the jury system, because it is that sacred protection that the greatest repository of power is not with the government, not with the president or a king or a dictator or a potentate or whatever, but with the people. And no citizen can have his or her liberties taken away unless and until a jury of his or her peers feels that the crime has been proven beyond a reasonable doubt. It's a wonderful system. It's not perfect, but it's great. And I know that a lot of people are watching or listening or reading about the Zimmerman case. I have nothing to do with that case. I know no specifics about it, but it always invites scrutiny. Heavy scrutiny by the media. And a lot of the media, not being critical, they're not really to report the news. They are editorializing. They have commercial programs that they have an agenda. So people need to watch these programs and filter it through the eyes of what are the facts. And quite frankly, none of us will really know what the facts of this case are unless we sat in the courtroom with the same rules that the jury has to follow. And we'll talk more about that as the program goes on.
That is something I was going to ask you about, but you already brought it up. Let's go to the phone. You have some calls already. Good morning. You're first.
Good morning. This is Kathy.
Good morning, Kathy.
Hi, John. Hi, Larry.
How are you today?
Okay. Yes, I have a general question.
Very good.
How does it work? Let's say a father dies. He was getting Social Security disability, and he leaves a 7-year-old daughter. Does she receive Social Security benefits?
My goodness, you have put me on the spot. In our law firm, my wife Janet does 100% of her practice is Social Security disability practice, and and that's a very specialized area of the law that I do not practice in. The office number is 352-547 4292. You are welcome to call. She will be happy to talk with you and happy to answer that question for you, because Social Security is a completely different court system, a completely different set of rules and regulations, and it is highly specialized. And the way we practice and the way many people practice now, in order for clients to get the best representation, it is necessary for lawyers to specialize, because the law has become so pervasive and so complex that it is impossible in this day to be an expert about everything. It's just like 50 years ago, we all had a family doctor who did everything.
Right.
He took out your appendix, he delivered your baby, he set your broken arm, he treated you for heart disease. He was a one-stop shop, one man does it all, because medicine wasn't as complex as it is, and law has done the same thing. So I apologize that I don't have an answer for you. I certainly don't want to tell you anything that's not correct, but if you will call our law firm, Fuller & Fuller, Janet Fuller specializes in that, and I know she'll be more than happy to answer that question personally for you.
Well, thank you. I appreciate it.
Thank you for listening to the show, and thank you for calling in.
All right, thanks.
All right, and you do have another phone call, John. Good morning. You're on the air with John Fuller.
Hey, good morning, Mr. Fuller. You could not be more correct in your assessment of the press.
Well, I'm not criticizing or beating up on anybody, but I do have observations to make that are based upon 40 years of trying some rather high-profile cases that's been involved with the press, and I think there's certain issues there that if you look at it intellectually, in an intellectually honest fashion, most people would agree.
Yeah, there's so much bias, especially by Channel 2 in Orlando. But anyway, I called you a couple of weeks ago in reference to a prenup. Now, I haven't selected a victim yet, but and you expressed that I should have the prenup prepared for the 5th Judicial Court and all that. And that's a good idea and stuff. I don't have a coupon, but how much would something like that cost? Just a very simple prenup. And I'll hang up and get your answer, John. Thanks for the advice last time.
Thank you for calling. And prenuptial agreements are valid in Florida if they're done properly. And the important thing that I want to stress is that if you're contemplating a prenuptial agreement, it needs to be addressed with your anticipated spouse long before the wedding. If you spring it upon your spouse in close proximity to the date the wedding's already been set, it's most likely that if it became contested at a later date, that it would be declared invalid. Prenuptial agreements are basically, it's hard to give a flat fee for them because it's not a one-size-fits-all. If you are an individual who's 70 years old and live in a Palm Beach mansion, drive a Rolls Royce, and have maybe $500 million in assets, you're going to want to be analyzing your estate plan. You're going to want to be analyzing the tax ramifications of it. You're going to want to be analyzing the domestic family law matters, and it's going to be far more expensive than if you are the middle-class American citizen who has some assets, a job, some debts, that sort of thing. Basically, the important thing is to get someone who is knowledgeable, because it is not always as simple as it appears on its face. So I think to get a prenuptial agreement done at its most simple, rudimentary basis, you will have probably somewhere around $750 to $1,500 in the most basic one done, because you got to meet with the client, go over all the assets, all the liabilities, make sure there's full disclosure, figure out what are the reasonable provisions you want to have in it, and then draft it and then submit it to the prospective spouse, and then negotiate some of those terms probably with his or her lawyer. And so on an hourly rate thing, you could easily have 3, 4, 5 hours tied up in that, and that would run somewhere probably a minimum of $1,500.
All right, and you do have another phone call. Good morning. Thank you for calling.
Yes, the Zimmerman trial has made me curious on the definition of peers. You know, a jury of your peers. It seems to me that he has all these women on his jury, and if you could just give me a basic definition of the use of the word peers for the jury, I would appreciate it. I'm going to hang up and listen.
All right, that's a
All
good
right,
question.
that is a very good question. A jury of your peers doesn't mean everybody whose favorite food is pepperoni pizza, if that's what yours is. It doesn't go that specific. It doesn't mean someone your exact age or your exact gender. What it generally means is that it comes from our citizenry. Jurors are selected in the Florida state court system from people who have Florida driver's license. There's a number of rules that have been adopted by our appellate courts that you cannot exclude someone from being a prospective juror solely on the matter of race. And there's provisions for the court to make an inquiry about that. Whenever a jury is chosen, you really don't get to pick a jury. It's somewhat of a misnomer to say select a jury. You really kind of deselect a jury because these people are brought into court at random. The computer picks them out of the pool of driver's license. They're all brought in. They're there. They're called up into the jury box. The judge asks them some questions. Then each lawyer gets a chance to ask them some questions. In most trials, each lawyer has 3 challenges, which are called peremptory challenges. That means he really doesn't have to have a reason. He simply could reject that prospective juror simply because of a gut feeling that person doesn't like his client or doesn't like him or her, or that they're just not the right person for that case. Then the other way to disqualify is for cause. If you say, my father, my uncle, my 2 brothers are all law enforcement, and I'm not sure that I wouldn't give more weight to the testimony of anybody who was a law enforcement officer than I would any other witness, that person is disqualified for cause because you're supposed to weigh all evidence equally without bringing any personal bias, prejudice, or preconceived opinions. So a jury of your peers means a jury of your citizens. It doesn't mean they have to be of the same sex or the same age or even the same race. But if you start systematically excluding people and there's a racial component, then the court stops and has an inquiry, and you have to articulate to the judge a viable reason as to why that juror, other than race, is being removed on a peremptory challenge.
Oh, wow. I never did hear that definition, so that was good to hear. All right, we do have another phone call. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller. Well, it sounds like you don't really get a juror of your real peers.
Well, like I said, it's not a perfect system, but one thing we have people who are all citizens, people who have not been convicted of crimes, and they live in this country, they vote, they are citizens, and they are all qualified by not having any type of physical limitation, such as hearing or vision, that would prohibit them from being able to see, hear, and understand the evidence presented. And that's what our country's made up of. You look at our country; it's a melting pot, and that's one of the things that's made it great from the very beginning. We are an amalgamation of people from all walks of life: rich, poor, big, strong, skinny, heavy. You name it, we have it.
Right. I'm blind, and it's been what? Maybe a couple of years ago or so. Well, I lost my sight and everything, so I was called, but I don't have a driver's license, I have identification, so I guess that's what they use, my state identification and call.
Yes,
so,
sir. Yes, sir.
Eventually, they pretty well said, well, if it's a hardship or whatever, they let me off. But so I guess in certain cases, if you do have certain impairments, if you vote, I guess they will call you.
Yes.
But my question is this. I noticed recently there were some changes in landlord-tenant situations, and I don't know if they were that good. And I've been in the past really, really victimized by tenants as a landlord in a little apartment. As a matter of fact, the thing has lost me more money than it's made money. Usually, you gotta pay the court fee, and then you gotta pay the people that do the eviction, and it's just absolutely. It seems like now, if a person skips out and don't pay you and do a lot of damage that exceeds what you got for the deposit, you end up, after paying all the fees, it seems like it's not worth it. I'm gonna hang up and see if you would address the changes that the governor recently signed, that the legislatures voted in regards to landlord tenants. Thank you very much. I always enjoy listening to you. You guys
thank you.
Have a good weekend.
Thank you very much. And also I want to thank you for being willing to try to serve, even though you do have a visual handicap. Most cases that I've been involved with have some type of documentary evidence, photographs, maps, sketches, PowerPoint presentations that are very visually oriented, so it can present a real problem. But I think you are to be commended and congratulated for the willingness to try to serve on a jury, even with the issues that you deal with your loss of vision. And I want to thank you for that and congratulate you and commend you for it. I am not an expert on landlord-tenant. That's an area that I don't regularly practice in. Generally speaking, my knowledge of the law is that the landlord, if he complies with the notice requirements of the Landlord-Tenant Act for eviction from a residential dwelling, and it differs between commercial structures and residential structures and mobile homes. If the time frames are complied with, technically the statute provides that he is entitled to recover his court costs and expenses incurred. That is a technical remedy that the law gives you. That's really all the law can give you. If the person does not have any assets, which is often the case when someone is being evicted, it's not a good. It doesn't give you a meaningful remedy, because, like my father used to say, and he grew up on a farm, you can't get blood from a turnip.
Mm-hmm. And you're ready for another call? Looks like you
Yes,
got
sir.
one here. Good
Nice.
morning. You're on the air with John Fuller.
Good morning. I have a question about something that you mentioned in a previous show.
Okay.
We were talking about the fact that ignorance of the law is no excuse, and Mr. Fuller, you said that a citizen is deemed by the court to know that something is against the law. Does that ring a bell with you?
Yes, as a general statement of the principle of our system, citizens are deemed to be on knowledge of the law, and if there is some obscure law, it can be a real hardship on people. But basically speaking, if someone is going to engage in say a contract in a specialized area, the law expects them to educate themselves on what the rules, regulations, statutes, or what have you are that control that body of law. And if you don't do so, you do so at your peril.
Okay, that's great, because I had a question. You mentioned earlier that we're covered by a patchwork of laws at the local, state, and federal level. And I have a question. I'm going to use a very silly example just to keep things simple, but let's say that there's a law that I'm not allowed to wear a green shirt on Wednesday. Okay?
I got it.
If a policeman, a law enforcement officer, comes up to me and says, Excuse me, but were you wearing a green shirt on Wednesday? If I didn't know the law and I answered that question, I could incriminate myself.
Well,
that's correct, isn't it? I mean, that's logical, right?
yes. For everything that we talk about, it's really hard to deal with in absolutes and black and white pronouncements because they are a variety of shades of gray. But basically, if you make a statement to law enforcement, you can incriminate yourself. Now, having said that, and this opens a whole different can of worms, and I'm not trying to needlessly complicate this, but so we don't mislead anybody, if you are a target for an investigation and you are in what is called a custodial interview or custodial interrogation, which means that the police are talking to you, and while they are talking to you, you are not at liberty to leave. You're not under arrest, but you are not at liberty to leave. If you are a target of the investigation, before they can ask you questions, they must advise you of what everyone knows from television as the Miranda warnings. And you then have a right to remain silent, and you know the litany. Everybody who watches TV has seen it on every Cops and Robbers show ever since the Miranda versus Arizona case came out in the late 60s.
Well, you've answered my question. It would seem to me that if a law enforcement officer asks me a question, unless it's the most mundane, trivial question, I'd be well advised to seek counsel of an attorney before I would respond.
Well, that would be your right. The Supreme Court has said that law enforcement has a right to make a custodial stop for purposes of seeking identification, and they also have a right to do a pat-down search of an individual if they have reasonable cause to believe that he or she might be armed. So that's called a Terry stop after the United States Supreme Court, the Terry case. They have certain rights to stop and inquire, who are you, what's your name, where do you live. Those types of things do not rise to the level of custodial interrogation that triggers the duty to read the Miranda rights to you. But you have a fundamental right before you talk to any law enforcement officer to say, I prefer to consult with my attorney and to decline to make any statement, however trivial, although they do have the right to get identification information from you, and you don't have a right to consult with a lawyer for that.
Mr. Fuller, I learn something every week on this show. Thank you, sir.
Thank you for calling. It's listeners like you and our other callers. We've had some great calls today, and it makes our job fun and easy, and hopefully it is something that provides information, and we're just delighted to be here. And if it weren't for you folks calling in, this show would be a lot less interesting.
Yeah, it was some good calls today too.
Really were, and I thank all of them.
Is the opposite true? Is a policeman required to tell you he is a policeman? You always hear that with the prostitution thing. Like,
no.
If you're a policeman, I can say, "Are you a policeman?" You're not obligated to tell me yes or no.
Well, I don't think these are getting really sophisticated into detailed facts, but police officers do not, if they're conducting an undercover operation, a sting operation, or that sort of stuff, they don't have to walk in wearing a label and a badge if they're trying to do an undercover drug bust. If someone specifically asks them if they're law enforcement, there are some laws as to what they can say in terms of not lying to intimidate someone to make statements or do things, and that opens the door into an affirmative defense to a criminal case known as the defense of entrapment, and that's a huge area of the law that's fascinating. And I tried a big case on that a number of years ago. with a reverse sting where law enforcement was selling a kilo of coke, and the enticement to the young defendant, who was about 20 years old, was a very attractive young woman who dressed very provocatively and encouraged him that if he would meet her and provide her with this, that she would bestow certain sexual favors upon him. And we had a trial on entrapment.
Wow, that sounds like entrapment to me.
I remember, in my closing argument, in the stockyards of Chicago, in order to lead animals to the slaughterhouse where they are hit with the batatois, where they hit them with this thing to kill them. Right. They have an animal that leads them into the slaughter and then goes out a gate, and it's actually called the Judas Gate and the Judas Goat. And that's the classic descriptive example of entrapment. Is when law enforcement goes out and gets somebody who entices an otherwise law-abiding citizen to do something that he or she would not otherwise do, and then lead them into the commission of a crime. That constitutes entrapment. And I made my closing argument based upon the Judas Goat and the Judas Gate.
My goodness, look at the clock. I guess I'll save my questions for next week.
How we doing? Well, I think with Zimmerman going on, we'll probably have some interesting things. I don't know how that'll play out, and I know nothing about it. But anytime our system has so much publicity, I really want the folks that view it to understand that the rules of evidence control what the jurors hear. They may not be hearing what any of the news channel talking heads are telling the populace at large about.
Right.
Because the rules of evidence are to filter stuff to make sure that only probative evidence that's relevant to the issue goes in. Not things that are speculative, not things that are inflammatory beyond any probative value, not things that are unreliable because they're hearsay. The judge rules on all those things and filters it. And the jury is oftentimes out of the courtroom when this evidence is being proffered. So unless you are going to go to that courtroom and sit there every day to listen, you're really not going to get the same view of the case that the jury does. And that's why we should not criticize jurors. And that goes true for the press in a lot of cases. I don't know about Zimmerman, but I've had cases that lasted 2 weeks, 6 weeks, 8 weeks, and even longer that were high-profile cases, and various people from the media would come in and spend about an hour in the morning and maybe an hour in the afternoon just before having to make their radio show or their television show or their press deadline, and then they would go out and write a whole article about what occurred in 8 hours of trial after seeing maybe 1 to 2 hour snippets of it. And that's difficult. And look, we all know everybody's overworked. Everybody's got a lot of responsibilities.
John, thank you for your insight on these things, and thank you for teaching us so much about the legal system that we're actually protected by. So it's always good to know what we have. What is your phone number again before we say goodbye?
The office number is 352-547-4292. We have a toll-free number, 855-534-2565. We have offices in the villages in Ocala, and if you have a legal problem that's in our area of practice, please call us. If you've been in a car wreck or have a civil dispute, business, commercial, Social Security, those are the areas that we focus on, and we'd be happy to try to help you.
Very good. And call us if you need that number repeated, or go on WOCA.com. Look at the guest list for AM Ocala Live. You'll see John's name on the Wednesday slot every Wednesday. Thank you, John.
Thank you very much, Larry.
We'll take a little break. We'll be right back.
Ocala's information station, 1370 WOCA. Ocala.
ABC News Now. I'm Karen Chase. Supporters call it major milestones in gay rights. The Supreme Court has